The 14th Amendment of the Constitution prohibits any state from making or enforcing laws that shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property, without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. Due process means the government actors must follow certain procedures before they may deprive a person of a protected life, liberty, or property interest. Also, whoever acts under the color of any law, statute, ordinance, regulation, or custom, willfully subjects any person in any state, territory, commonwealth, possession, or district to the deprivation of any rights, privileges, or immunities secured or protected by the Constitution or laws of the United States shall be prosecuted. Giving clarity to the definition of the color of law, it could be said that it is the abuse of power by those who violate laws under the guise of state authority. Moreover, a judge is determined to be trespasser of the law if he or she violates laws to which they swore to protect. If this was to occur, then subject matter jurisdiction is lost, and any orders of the court become void. Additionally, a judge who wars against the Constitution, or acts without jurisdiction, has engaged in treason to the Constitution. Judges and attorneys are obligated to report their peers for acts of treason, as required by law, and failure to do so may result in themselves being guilty of treason. Therefore, why is it that the government can steal and defraud the American people? This question was a result of a series of activities performed by the Florida judiciary to defraud a litigant in the 11th Judicial Circuit Court and supported by the 3rd District Court of Appeal and the Southern District Court of Florida. These activities revealed the government's willingness to sacrifice children in exchange for revenue. The scavengers of this practice are the attorneys, whose advice is never for parents to rebuild relationships, and also the judges who collaborate with them to deceive individuals who are unaware. One client became the victim of this practice when he realized that attorneys are willing to betray through representation. Attorney Renita Henry is one known scavenger who omitted her client's information and even admitted her act to opposing counsel Emily Phillips in an email dated December 17, 2018. She would follow up by informing her client that attorney Emily Phillips would move forward with her original child support and it will not be up for discussion. This statement was made after she decided to withdraw from the case, which was on account of her client refusing support to the decision to omit state tax, city tax, and mandatory retirement salary deductions from her calculation. Subsequently, those salary deductions would automatically transposed into net income and be misrepresented as a material fact to her client and the court. While advising her client, she indicated that the omissions were only temporary. Not only did attorney Emily Phillips refuse to report the knowledge of fraud, but General Magistrate Deborah Nabet Frankel and Judge Scott Bernstein, who were the other officers of the court, also acknowledged and accepted the act of omission as being within the parameters of the law. General Magistrate Deborah Nabet Frankel was the second individual to advise the litigant that the omissions were only temporary and would be corrected at the final hearing by the judge. But that was never to be as Judge Scott Bernstein, on April 29, 2019, advised the litigant to file an appeal of the verdict. Nonetheless, the applicable law states that if a court official is found to be biased or prejudiced even before fraud occurs, they are required to excuse themselves from the case, and a different official must be appointed. Through judicial canon guidelines, it is also a judge's responsibility to report any knowledge of impropriety to the relevant authority. This was the beginning of a tale that meandered with injustice and one where the victim got vilified while enabling attorney Renita Henry to file sanctions against her former client for his decision to challenge the act of omission. Further discriminatory acts prevailed as the 11th Judicial Circuit Court issued a writ of bodily attachment to ensure that the infringement of Mr. Brooks's rights would be without any objections. It is preposterous that in a developed country such as America, people's rights are sacrificed and laws compromised for the generation of revenue. At first glance, the Title 4D program seems structured to ensure that children are financially cared for, but a closer look displays a sacrificial altar where the smoke of unhappy households emits while enormous funding is derived. Moreover, it was revealed that the amount of funding received from the federal government is directly proportional to the child support that is collected. For that reason, this program directly targets those within less functional relationships. But, if the mission is to truly safeguard the well-being of children, wouldn't it be better to educate parents on the potential benefits of quality communication after the dissolution of a marriage or relationship? For democracy and accountability to be present in America, there need to be fundamental changes to the selection processes of those within oversight agencies. Police, attorneys, magistrates, judges, and many others are too empowered and lacking moral compass to provide oversight of their colleagues. But, surprisingly, agencies such as the Department of Justice, the Florida Bar, the Judicial Qualification Commission, Miami-Dade County State Attorney Catherine Fernandez-Rendell, United States Attorney Mackenzie LaPointe, Chief Judge Neshin Safai of the 11th Judicial Circuit Court of Florida, former Chief Judge Bertula Soto of the 11th Judicial Circuit Court of Florida, Florida Governor Ron DeSantis, and numerous senators within Florida have failed to function. The listed agencies and individuals have all failed in their capacity to prevent any further violation of Mr. Brooks' civil rights. Alarmingly, all of the agencies that have responded were either uninterested in a military veteran whose rights were egregiously violated by the men and women who took oaths to protect and serve, or were unresponsive to the complaints. Agencies such as the Miami-Dade State Attorney's Office, the Florida Bar, and the Judicial Qualification Commission identified the act of omitting information during legal proceedings as not being a criminal violation or within the ethical realms of the professional code of conduct. These responses were provided while receiving attorney Renita Henry's admittance to omitting her client's information, which she further stated as being a deviation from the guidelines. Where do Mr. Brooks and victims like himself go for relief when the judicial system is so tarnished that it is unable to function in an unbiased manner? It is on account of this question that many litigants are forced into frustration and allow the infringement of their rights to be unrestored after the government's unwillingness to hold officers of the court and their colleagues to a higher standard of ethics and professionalism. Ultimately, this will, if not already, result in laws that are not penalized by a jurisdiction or unconstitutionally vague. Wherefore, this also enables police, attorneys, magistrates, and judges to perpetuate the abridging of the privileges of many Americans. Maybe, it could be said that the reason why Mr. Brooks's rights are of no value is that the violation commenced in a child support matter. But, if that were to be true, then Florida Statute 61.30 is of no value where due process or the preservation of rights are concerned. Primarily, the government has in place procedures for enforcing child support orders and considers non-custodial parents to be more of a supply chain for the Title 4D system. But, why is this so acceptable by a society that has conformed itself to a fallacious belief where an entire group of people is identified as being uncaring towards its offspring? Mr. Brooks's experiences included but were not limited to attorney Renita Henry's omission of his information, which subsequently breached Florida Statutes 61.30 and 839.13, attorney Emily Phillips, General Magistrate Deborah Nabet Frankel, and Judge Scott Bernstein's collaboration in fraud on the court. Judge David Miller's recusing himself minutes after making a verdict. Judge Samantha Ruiz Cohen adjudicating without subject matter jurisdiction and then refusing to recuse herself, and attorney Amelia Warchell's submission of a misrepresented information, and finally, federal judge Cecilia Altanaga's dismissal of a case 20 days before the submission of summons were completed. These and other acts culminated in the color of law, judicial fraud, fraud on the court, and 42 U.S.C. 1983 civil rights violation. We recommend that this video not be viewed as providing advocacy for parents to reject their responsibility to their children, nor does it support those who ingeniously apply laws to generate revenue while projecting the mothers versus fathers division that exists in society. Moreover, while the underlying purpose is being fulfilled, children find themselves in the kill zone of their parents' battlefields. This video demonstrates that there is no objectivity to instituting a program that favors injustice practices.